Good day, everyone. My name is Scott Reich, and this is Crime Talk. And you are getting the weekly recap from March 6th, 2023. All the top stories located in one convenient location. Enjoy. We'll see you next time on Crime Talk. All right. So last week, February 23rd, the court had a hearing in the Lori Vallow and Chad Daybell matters. And it was in regards to Chad Daybell's second renewed motion to sever the cases. As you may recall, the state indicted Lori Vallow and Chad Daybell, and their position, the state's position, has been that the trial needs to remain together. Well, there's lots of times issues for what they refer to as severance, which is to separate the trials, the joint trials. When they want to bring separate cases together, that's called joinder. So here, since they're already joined, now they are severed. So what does that really mean? Well, like I said, you had Lori Vallow's case, Chad Daybell cases under the same indictment, and they're going to go to trial. They were supposed to go to trial on April 6th. Anyway, there was a hearing held on March 2nd in regards to Chad Daybell's motion to sever. That motion is granted by the court. Now, in doing so, in the court's order, it's kind of a little discombobulated. Let's just say it that way. All right? Court relied on the standard of review, which was set out in some cases there in Idaho, which they need to look at. He also looked at Idaho Criminal Rule 14, which provides basically the general rule to make a decision as to whether there's joinder or severance and whether there would be any prejudice to the defendant. Once again, the government relies upon some case law and authority, but the real gist of what the court had to look at is under the rule. And it says the defendant has to be shown that the joinder will result in unfair prejudice. And it says that the court, when they've already decided that these trials should remain together, to separate them, again, the court has to make a judicial termination of every criminal proceeding because the defendant's adequate procedural safeguards to prevent the prejudicial joinder of charges against them. What does that really mean? It means the court has a duty to make sure everybody gets a fair trial. So then it says, to justify severance of trials previously found properly joined, the court should consider three potential sources of prejudice in analyzing the state's position in regards to the prejudicial joinder. First, will the jury get confused by the evidence and convict the defendant of one or more of both crimes when it would not convict him of either if it could keep the evidence properly separate? Next, the defendant may be confounded in presenting defenses as where he desires to assert his privilege against self-incrimination with respect to one crime but not the other, or that the jury may conclude that the defendant is guilty of one crime and then find him guilty of the other because of the criminal disposition. So what does that really mean? Okay. First, is there evidence that basically shouldn't come in as it relates to both defendant? Well, all of the evidence is pretty much going to be the same, which is what the prosecution has been arguing. So that doesn't make much sense. Next, the defendant may be confounded in presenting defenses where he desires to assert his privilege against self-incrimination with respect to one crime but not the other. So that's usually severance of charges where that comes in, where you say, hey, judge, my client is charged with a bank robbery, and he's also charged with possession of a weapon. He can testify to the bank robbery because he was there simply to deposit a check, but he may have self-incriminating evidence as it relates to the gun possession charge, so therefore you should sever that. Well, that doesn't seem to make much sense here unless Chad Daybell has been making an argument that says, Judge, he can testify as it relates to one count that he's charged with. Remember, he's charged with the death of J.J. Tiley, some financial crimes, and then obviously the death of his wife. So could he be saying, I could testify to counts 1 and 2, but I can't testify to count 3? Interesting. doesn't necessarily seem to fit. Or then it says that basically the defendant could be found guilty because basically if he's found guilty of one charge, the jury may think, well, if he's found him guilty of one charge, he may be guilty of the remaining charges as well. So then the court goes on and says, based on the granting of severance to provide additional time for evidentiary testing, defendant Chad Guy Daybell's April 3rd, 2023 jury trial is vacated. Was it just me, or did it completely miss all of the rules in Rule 14 that the court put in its order and said, separate the evidence, assert his right to remain silent as it relates to one count but not another, or basically he could be found guilty just because he's got a bad guilt or his prior guilty disposition. He must be guilty of one. He must be guilty of everything. But no, the court goes through all that and then just says, based on further DNA testing, he's severed out. That doesn't make a whole lot of sense to me. I'm not exactly sure what the judge was doing. Now, as you may recall, the prosecution conceded that they were literally getting test results back from DNA 2 weeks ago. The defense has an opportunity to test those results, to look at the data, have it retested. Maybe it warrants even further testing. But of course, we don't know because, well, remember Judge Boyce says we're all too stupid to understand. And it's, everyone who hears anything about the case obviously will be so prejudiced that they could not be a fair and impartial juror. Doesn't make any sense. So he's been doing everything in chambers, basically, or in a closed courtroom. That's why the ruling doesn't make sense. He issues a generic order, but it doesn't explain actually what he did. As you remember, Mr. Pryor, Chad Daybell's attorney, said they needed more time, that he wasn't going to be effective, hadn't started anything. The court denied all of those. But then I said, remember, the court has to balance the interests of the defendant's right to a fair trial and effective representation against that of a speedy trial. Lori Vallow hasn't been willing to waive speedy trial. Therefore, she has to go. And does this buttress Lori Vallow's argument as it relates to her case should be dismissed for a violation of speedy trial rights? Possibly. Don't think Judge Boyce is going to change his mind on that. I mean, he did change his mind on this. I'm a little surprised. But I think it grants credence to the motion to dismiss based upon the violation of her speedy trial rights, because all the court had to do was give her her day in court, even though the prosecution and the court said, no, we're going to do these trials together. Well, apparently you can sever the cases and everyone still gets a fair trial. So it makes you wonder why he couldn't have done that months and months ago. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Letecia Stauch, that's right, 3 years after 11-year-old Ganesh Stauch was killed, his stepmother is set to go to trial in proceedings that are expected to last at least 6 weeks. How that's going to take 6 weeks to prove that case, I do not understand. Anyway, Letecia Stauch faces numerous charges in connection with the death of Ganesh Stauch back in January of 2020. He was reported missing from the Lorson Ranch neighborhood in El Paso County, Colorado on January 27th, 2020. It's the same day that the prosecutors alleged that Stauch killed the boy in his bedroom, and she has pled not guilty by reason of insanity in the case. And during a court hearing Thursday afternoon, it was revealed that a report related to an additional mental health exam requested by the defense team had not yet been provided to the court. As you may recall, Miss Letecia Stauch was arrested in South Carolina back in March of 2020. Later that same month, Gannon's remains were found in a suitcase near a Florida highway. They were found about 6 weeks after Stauch drove there in a budget rental van. Now, since her arrest, Stauch has been held without bond on felony murder charges, and they include first-degree murder after deliberation, first-degree murder of a person under 12 by someone in a position of trust, child abuse resulting in death, tampering with a deceased human body, tampering with physical evidence, 7 counts of crimes of violence for use of a weapon, which include firearm, blunt object, and sharp objects, and 1 count of crime of violence causing severe bodily injury or death. Jury selection is to begin on March 20th, and they believe it could take 2 weeks. Now, Stauch is also accused of slipping out of handcuffs, attacking a deputy as she was transported from Colorado from South Carolina following her arrest, and plotting an escape from the El Paso County Jail. A separate criminal case is pending against her related to those particular incidents. Next on the docket, Bryan Kohberger. Hey, come on, who doesn't separate their garbage at night from everybody else and do it while wearing gloves? Hey, maybe it's obsessive compulsive. I get it. Or is there something nefarious going on? Well, Pennsylvania officials have revealed that the Idaho College murder suspect, Bryan Kohberger, was doing when they raided his home, his parents' home, actually, and they arrested him in the early morning hours of December 30th. Now, obviously, Kohberger had been under surveillance for some time. In fact, agents had tracked him as he and his father drove from Washington State, where he was the criminal justice graduate student, back to their residence in Pennsylvania. Now, Mr. Kohberger was found awake in the kitchen area, dressed in shorts and a shirt and wearing latex medical gloves, and apparently was taking his personal trash and putting it into separate Ziploc baggies. I mean, that's totally normal, right? Who does that at midnight? I don't know. That's weird. I can't wait to hear Bryan Kohberger's explanation for that. I'm sure it's completely reasonable and plausible, because you can't have your garbage mixed in with anybody else's. Anyway, officers were able to take a cheek swab for DNA and seized a silver flashlight, 4 medical-style gloves, a T-shirt, a sweatshirt, some shoes, and socks, and the shorts that Mr. Kohberger was wearing at the time. I can't wait. And now that Mr. Kohberger has another co-counsel on his case, certainly there should be no delay for that preliminary hearing at the end of June, and I can't wait for the reasonable explanation as to why he's separating his garbage. Let me know. Is that normal? Show of hands. Who separates their garbage? Alex Murdaugh. Do you remember during his sentencing when Judge Newman said that he hopes that Alex Murdaugh will think about his wife and his son, Paul, every day and have that image in his mind every day? The judge didn't mean it as a compliment, as Alex Murdaugh kind of took it as, of course I think of him every day because I didn't kill him, right? But it really was, I hope it haunts you every day. Well, guess what? Now that Alex Murdaugh has made it to the South Carolina Department of Corrections, he's going to get that opportunity. He's going to have a lot of time to think on his hands. Well, currently he is under 24-hour surveillance in a concrete cell at the high-security facility called the Kirkland Correctional Institution. Now, officials there are concerned that given his status in the high-profile case that obviously the nation watched, that he could become a target for other inmates. Apparently, he is having all his meals taken to his cell, and on a very limited basis, he is given a break from confinement, and at least one prison officer will escort Mr. Murdaugh until he spends at least 45 days there while they do all their evaluations and testing to see which is going to be the appropriate facility to send him to serve his multiple life sentences. Now, this Kirkland facility, it's kind of what we refer to as a diagnostic and processing center. They test people like, hey, if you need to get your GED, we're going to send you to a facility. If maybe you don't have a lengthy sentence, but you could use a career, we're going to send you somewhere where you can learn how to be a welder. Those are things. But when you have a multiple life sentence, guess what? they can really put you anywhere, and it's probably going to be a high security prison. He may stay at the South Carolina's, the Kirkland facility for his stay. And it's one of the more secure facilities, higher risk facilities there. And like I said, he's probably going to be walking around with killers, sex offenders, and armed robbers, people that have committed violent crimes. This Kirkland facility has had some issues. Back in 2017, it was highlighted when 2 inmates strangled 4 others after luring victims into their cell with the promise of drugs and cookies. And the Kirkland's notorious reputation is also highlighted by a recent report that found it had the highest death rate among any prison in South Carolina. So between 2015 and 2021, 160 inmates died at the state-run institution. As I noted, Kirkland is the facility in South Carolina where male prisoners are first sent after conviction, and then once the assessments are done, they will decide where he's going to spend the rest of his natural life in prison. Obviously, his status is double murder. Remain pretty likely that he's going to stay there. So why is the prosecution so afraid of allowing cameras in the Lori Vallow and Chad Daybell matters? Could it be 3.6 million reasons thus far? All right, let's give credit where credit is due. Nate Easton of East Idaho News took it upon himself and requested all of the costs to date to prosecute Lori Vallow and Chad Daybell. And what did they uncover? That the number will only grow given the cases have now been severed. But Lori Vallow's trial will begin on April 3rd of 2023. Chad Daybell's new trial date has not yet been obviously rescheduled yet. But Madison County, the city of Rexburg, and Fremont County provided an estimated cost of the cases between late 2019 and December of 2022. Madison County has spent approximately $416,520. The city of Rexburg spent $1,465,701. And Fremont County has spent another $1,750,000. So 3 years, 3 jurisdictions, $3,632,221. And that number is going to continue to grow. The next question is, what cost $3.6 million? Well, Fremont County is currently paying all public defense fees, but at the end of the trials, Madison County is supposed to chip in a little bit as well. Well, I can guarantee you the public defenders representing Lori Vallow have not received $3.6 million. The bulk of that is the cost of prosecution. There you go. So, as you know, 3 years ago when the kids went missing, Lori and Chad run off to Hawaii to get married. Lori Vallow is returned to the great state of Idaho regarding the charges of abandonment of her 2 children, JJ and Tylee. Then the abuse of corpse charges come around when, that's right, the bodies of JJ and Tylee are found on Chad Daybell, Lori Vallow's new husband, found on his property. Then the murder charges are turned into a death penalty case. And so, like I said, the estimated cost could be $5 to $6 million with 2 trials. Is this why the prosecution doesn't want cameras in the courtroom? If they blunder this case, as they seem to have done along the way, and I wouldn't want the world watching me either.